Was the paint
Most
job?
of it, yes.
Okay.
Most of it. There's still, it's like the whole place should have been repainted, not just this touch-up. But I had to pick, he was in a hurry, he kept saying, I don't want to come back. And the whole thing in the very beginning with the walkthrough is when I showed him stuff, he always said, nobody's gonna notice, nobody's gonna, I got tired of, I said, I notice. If I notice, a new potential buyer is gonna notice. And you do not want to connect your name to something you did without being proud of it. And it is shoddy workmanship. So I had to go to this source, because he just wanted to get done, get out of there, get paid. I've had closet doors fall off that he's put on. The basement floor I had to do myself, and it's like, you know, why do I hire somebody and pay almost $5,000 for all of that when I have to do all of it myself? I had to caulk, I had to do this, I had to do that.
I don't know,
We don't
ma'am.
have time. My son works 14 hours a day. My daughter helped me do the trim work he said he'd do and didn't do.
You know, if it's as bad as you say, ma'am, I don't know why you paid him.
Yeah, right. I said, I really learned a lesson, but I knew not to pay up front. I knew that, so you keep learning.
Payment is not really an admission that plaintiff is happy, but it doesn't really help her. Let's see what the judge says.
There are a lot of problems with this case. The first problem, it starts with the agreement, okay? And I tell people that come in front of me all the time, you have to have a clear written agreement between you and somebody who's going to be doing work for you, setting forth what is going to be done and how much it's going to cost you, and maybe when it's going to be done or how long it's going to take. And part of the problem with this case is we don't have that here. I've got an invoice dated February 8th that's got a big X drawn through it with work that's to be done and an amount. I've got another invoice, again dated February 8th, with one of these sticky things attached to it, with different amounts and a different description of work to be done. I've got another invoice dated February 8th that is yet again different in terms of the description and the amount of money to be paid for work to be done. I have another invoice dated February 6th with lines all through it, X's through it, with another different description of work to be done and an amount that it's going to cost. I have another invoice dated February 11th. This doesn't have any X's drawn through it, and is very detailed in terms of the work to be done and how much it's going to cost. I have another invoice dated March 10th with one of these sticky things attached to it with another description that's different of work to be done and how much it's going to cost. And there's, all of these invoices have amounts written on here that say paid, the check number and how much. And I can't figure out what the agreement is between the two of you as to what was going to be done and how much it's going to cost. And that's a big problem for both of you, because if the case is to end up in court, if there's a dispute, the judge has got to figure out, first of all, what the agreement is. Before the judge can decide whether anybody is entitled to any money, the judge has to know what the agreement is to determine whether there's been a breach or a violation of the agreement. And I can't tell exactly what the agreement is because this is all so confusing. The best that I can figure out is that there was going to be a paint job done on the first floor of this house for $1,500. And we don't even know more than that, because the defendant in this case, Mr. Holfer, says it was going to be one coat. Plaintiff, Ms. Karen, says it's going to be more than one coat. So we even have a dispute as to that. But apparently there was going to be a paint job done for $1,500. So that's kind of what I'm going to start with in deciding who should get any money, if anybody. The next thing that has to be proven in this type of a case is whether or not that agreement was violated. And the agreement would be violated if the paint job was done shoddily, if the workmanship wasn't done properly, if the painting wasn't done according to a reasonable person. If the paint job was not what a reasonable painter should do, then you'd be entitled to money. Okay, and that's where we have another problem with this case, because it's very hard for me to determine that. Now, it's important to know, Ms. Karen, that you have the burden of proving that. You are the plaintiff. You are suing. So you have to prove to me that the paint job was shoddy workmanship, wasn't done properly, okay? Mr. Hofer really doesn't have to prove that he did the work properly. You've got to prove that it was done improperly. And there's some problems with that. The first problem is the pictures that you have, which show the shoddy workmanship, really aren't very good in terms of doing that. And I'm not saying it's your fault. All I'm saying is that the pictures just don't do a good job of that. I think taking pictures of this sort of thing is hard to do because they just don't show the bad workmanship. I see a whole lot of pictures here. I see things circled where things aren't done properly. And I can kind of see what you're talking about in some of these pictures, but not real well. And in some of these pictures, I don't see anything that's wrong. And I think it's because taking these types of pictures to show this just isn't a good way of presenting it in court. You need something else. So that's a problem in terms of you proving the case, is that these pictures just don't do a good job of that. The other problem that you have in terms of proving your case is that you paid Mr. Hofer. Now, you gave me some reasons as to why you paid him. You felt sorry for him. He had mortgage payments, and you apparently had a big heart and didn't want to see him miss a mortgage payment, or for whatever reason. You thought he should get paid, even though the work wasn't done properly. And, you know, that may be true, but it doesn't help your case in court, because what it seems like in court is that the problem really wasn't all that bad, because most people, if the workmanship isn't done properly, they don't pay. They may make a down payment to get started, but if they don't like the job, they say, I'm not going to pay you because you didn't do this, this, and this. And then you come to court, and it makes your case stronger. You didn't do that, which, as I said, doesn't help your case, because it leads me to think that the job wasn't as bad as you said it was. The other problem that you have is, in terms of damages, even if I were to find that the job was done improperly, I think Mr. Hofer would be entitled to something, because he did something here. It's not like he didn't do anything. And what you would be entitled to would be the cost that you'd have to pay someone to fix the job, to make it up to a reasonable man's standard, to make it look like the job was done properly. And I don't know if that would be the full amount necessarily. I don't know that you need a whole full paint job here, assuming that the paint job was done improperly. I think you might need some touch-up work or something, but not $1,500 worth of work. But I don't quite have to go that far, because I am going to find that you haven't proved to me that the job was done improperly. I'm not saying that he did a good job. I'm not saying that Mr. Hofer necessarily did what he was supposed to do. I'm saying you didn't prove the case, largely because of the pictures and largely because you paid him, even though he said he didn't do the work properly. And I'm just not convinced here in court that the job was done improperly. I think a better way for you to have done this would be to bring in somebody who could testify as to what the paint job was like and what specifically was wrong with it. And I could listen to that person, and that doesn't mean you would have won the case, but I think it would have made it a stronger case. An independent person that said, I looked at the paint job and this was wrong with it, this was wrong with it, this was wrong with it, and I can listen to that, and that would be perhaps more convincing than pictures, but that didn't happen. So, for those reasons, the case is dismissed.
Well, the judge really nailed the issues. There was really no well-written agreement. Plaintiff didn't prove damages, and the plaintiff has the burden of proof. Case dismissed and case closed. If you find that you are involved in a dispute that you cannot resolve, small claims court may be the answer. Thanks for watching Case Closed. I'm Charlie Langton.